Yeah, no, this is good. We're going to get introduced first.
Okay. So, good morning. Welcome to the second day, or second and a half day of the TPI Aspen Forum. Now we are honored to have Brian Sullivan, who's a senior national correspondent for CNBC and anchor of Worldwide Exchange, interviewing Makan Delrahim, who is the Department of Justice Assistant Attorney General in charge of Antitrust. Obviously, each of them has much, much longer bios, which you should read, but I'm not going to, so that we can get on with the show.
I like it, Scott. Thank you very much. Appreciate that. That's the best intro I've ever gotten. Good morning, everybody. Big fan of the short intro because we've got a guest of honor here who is a pretty big deal, and he's a relevant and important guy to everybody in this room. And I love these Institute events because you learn what you don't know. And what I learned in the last 36 hours was I don't know a lot, and I appreciate everybody being gentle and kind and talking to me in a way where I can understand. But what I do know is that this is a perfectly timed panel because of the news that you guys all know by now that came out last night and this morning. It's probably the top business story in the United States right now, and it is about the state attorneys general. And so I am really honored and pleased to have our guest here, Makan. I think he is, couldn't have planned this. Now, you didn't plan this.
I did not.
Because it couldn't have been planned better. It's almost too perfect.
I get accused of a lot of things. That is one I won't take credit for.
You are too perfect, my friend. I've learned that about you in the last few hours. All right, so let's just jump right in. And I don't have any genius questions other than you obviously know the story. Can you add anything to it? Is there a timeline? Are you working with the state attorneys general?
I think it is safe to say that we have been, as the story also mentions, we've had communications with the state attorneys generals where we think that in all matters, all investigations of the Justice Department, the Antitrust Division, where we can work in a cooperative manner with state attorneys generals, we do work together. I think that's also just good government. It reduces the burden on the subjects of our investigations. And so we intend to operate in that mode.
Do you have an idea as to how many states might be banding together in this concerted effort?
I think it's probably safe to say at least, more than a dozen or so, a couple of dozen state attorneys generals have expressed an interest in the subject matter.
Bipartisan?
Bipartisan.
Do you have a timeline?
We don't have a specific timeline. We have an investigation, as I'll refer you to the press note or alert that we had issued. We would be taking a broad look, and we will look at it in with no preconceived agendas.
Would it be sometimes states and the federal government have been known to butt heads? I mean, I've heard this.
I can't imagine that happening.
And sometimes states have been known to butt heads with other states. Do you envision anything, whatever may come? Do you feel like you have a good relationship with many of these potentially involved states? Would it be a coordinated, sort of dovetailed group effort? Or do you envision that you would have different goals and agendas?
I don't think we would, again, it remains to be seen, but I anticipate it would be in a cooperative manner. That benefits, I think, everybody involved. States and their enforcement objectives, as well as the parties, and making sure that we are engaged in an investigation without creating undue burdens. It has been known, I'll refer you to the Sprint T-Mobile transaction, where some members of the states might go a different direction than some other states and the federal government. But that's just part of the challenges when you have 52 enforcement agencies doing antitrust in the United States.
Is that 51 too many?
Some have made that argument. Some also point to China that had 3 agencies back when they created their antitrust regime in 2008. Last year, they streamlined it to have 1.
And?
There's something about efficiencies that we care about.
It is the wording.
Look, and I'm not trying to be flip here
No.
about it. I think there's an important role for state AGs, particularly for intrastate investigations and matters that specifically affect the local communities. But it, I think it is important for us to constantly review our whole system and see, does the current enforcement apparatus continue to make sense? And if it doesn't, policymakers should take a look at that.
Well, and you're not, I'm certainly not being flippant. I think you're being very candid, and we appreciate it. It's an important topic, and you use the R word, and I think that, language is important here. He said review, and I feel like what you guys have at the DOJ right now is a review based on the article, based on CNBC reporting overnight and this morning. It sounds like, according to the people that we've talked to in the States, that they may be ready, willing, and or able to get more aggressive. Based on what you know, do you feel like the states may be looking at more of an investigation rather than a review? Potential subpoenas for big technology.
Again,
companies.
just consistent with our policy, not discussing our internal investigations. I think it's safe to say that we're all in the same place, having had conversations with the state attorneys generals at the federal level and the state AGs. I don't think, there are different stages of an investigation. So,
is there any kind of a timeline that you've discussed or you can discuss here?
no, not that I can discuss. We've had some discussions about, at what point, the way that we operate, we enter into confidentiality agreements with state AGs so that, the integrity of the investigation is preserved. We enter into common interest agreements. In the event we decide to enter litigation, I won't comment on that.
The confidentiality agreement's confidential.
Confidential.
What's your view generally, Makan, on, I don't know, I hate to use the term big tech. I mean, what industries are we talking about? CNBC, we call them the FANG stocks.
Yeah.
I don't think the N is involved here. The Netflix is not. But, the other ones that we talk about, certainly. What's your view generally?
Look, I think we're living at a time of incredible innovation and prosperity. We've had great efficiencies that have been brought to consumers through some of the innovations that we've had. But there's also undeniable that people are asking questions about the market power of a few number of companies in particular marketplaces. And I agree with you. I don't think it is either useful or productive to lump all technology companies together. Does Google compete with Facebook? You don't go to Facebook to search. You might connect, but from an advertising standpoint, they might be. I don't know, but that's part of what an investigation would reveal. What markets are they in? But and it could be perfectly fine, as I've said before, and the Attorney General said at his confirmation, big in and of itself is not bad. It's big behaving badly. So in this country, in our system, we encourage companies to strive for market power through innovation, better products, greater efficiencies, lower prices, and that's a good thing. Mm-hmm. But once you get that, you don't want to create a moat that illegally preserves that market power. You want them to continue to strive and compete.
Is there a Standard Oil in this room?
I don't know if I know any
John Rockefeller,
representatives.
if you're here, stand up, please. I think he built, this is Astor. I'm sorry, not Rockefeller.
So I'll refer you to a speech a month or two ago where I discussed some of the parallels of the Standard Oil case to some of the issues we continue to deal with today. And, Standard Oil was an innovator, created a lot of efficiencies at the time, but then there was a time where they violated the laws and actually prevented competition. So the maintenance of monopoly, like what Microsoft was held to be liable for by the D.C. Circuit Court of Appeals, is that illegal maintenance of the monopoly is a problem. So that's what we would look for.
And monopolies, as you said, big is not bad. Monopolies are not, I'm not saying anybody in the room has a monopoly, but monopolies are not illegal. A lot of people think that they are. They're
That's
not.
correct.
Using that to, as you said, block competition. You have been in your conversations with us on CNBC, my colleague David Faber, in your writings, you have come back to this word efficiency many times, and you have talked about how, there needs to be verifiable efficiencies for the consumer, for a deal to be good for the public. For the most part, do you feel like the framework of where technology companies sit right now is good? Is it efficient for the consumer?
It's a broad question, and let me break it down into a couple of specifics. So when we look at a merger, we apply a different set of laws, and we do recognize efficiencies under Section 7, where the merger laws, the merger law that we apply to a particular proposed transaction, and the efficiencies for them to be counted from a legal standpoint, they have to be merger specific, meaning that these could only be attained through the transaction, and they have to be verifiable. They can't be pies in the sky 10 years from now or whatever it is. And so there's specific guidelines that we have to follow to recognize efficiencies. Broadly, though, outside of that, when you're looking at conduct matters in Section 2, which is monopolization type of investigations, we look at efficiencies, and that's something that, I think generally our laws encourage greater efficiencies. With efficiencies come greater ability to compete, which would presume an interest in lowering prices to consumers, but also having greater output. So that is, I think, to the extent we're looking at that, that's how we would look at it. I have no idea, without doing an investigation, of whether or not the current system or any specific company's position in that system creates maximum efficiencies. Certainly, when you have an innovator that disrupts incumbents, they come with some efficiencies that are very beneficial to consumers. I'll point out, Netflix to some of the MVPDs, they provided a lot of benefits to consumers that wasn't available at the time. Access to a lot of content at one time, the usability of it, the portability of it, the interface. Now, these were, offerings that could have been offered by any programming provider, but they weren't because there was no need to. I think Netflix, and to some extent Amazon Prime, did disrupt that system, and now you're seeing more and more movement into that, which I think is generally a benefit for consumers.
And it's so amazing as just a consumer when you look at sometimes big gets big simply because it's better. It's better than the other competition. I mean, you go back to Netflix, Microsoft, or Netscape, Microsoft. I mean, would anybody here argue that the first Explorer was a better browser than Netscape? I don't think anybody in the room would argue that. So,
I don't know how many people I might remember what the first Explorer would have even done.
What are you saying? I'm not that old. We're the same age.
I think I'm older than you.
By like a year. Let's take it easy. So I think that big, sometimes just big, I honestly, you meet people, you say they can't live their life without Google. They can't even go to the grocery store without Google Maps, even though they lived in the same neighborhood for 12 years.
It's probably hard to do
Gmail
that.
is free. And so, no, but I mean a serious point of...
I can't find my office without using Waze.
There you go. Just make sure you mark where the police are. Hit the orange button, visible, non-visible. Not that I would know. But when you look at, it brings up an interesting discussion because when you go back through antitrust law, so much comes down to price for the consumer, but so many of the offerings of companies in this room are effectively free to the consumer. How does that play into any analysis?
So I think it's important. You raise an important point because there's a lot of discussion about antitrust.
Took me 10 minutes to get there, but I got there.
It's good, though, because it is an important point because a lot of people, I think, misconstrue or misunderstand antitrust laws only affecting price. And when there's not a price effect that could be shown, then there must not be a violation of the antitrust laws, and that's just not accurate. I gave a talk at University of Colorado in this same state 6-7 months ago, where I talked about free offerings and how antitrust law could apply. We've had free products in this country for decades. Broadcast television. is something that is free to the user ultimately, but it's really not free. We don't have a free lunch in this market economy. Who pays for that is the advertiser, and very handsomely, particularly when it comes around Super Bowl time and other times. So it's really not free. When you look at a search or social media product, is that really free? It might be free to you, but not free to somebody else. And so that's one measure. But antitrust laws are not limited to just price effects. We look at innovation effects. We look at quality. We look at a number of things. And some of these were, even in merger context, was specifically endorsed by the D.C. Circuit in the AT&T Time Warner decision that they mentioned.
And that's so important. I think it makes your job so much more difficult, because going back through antitrust law, big company, raising prices, bad for consumer, pretty easy target.
Right.
Here we have pricing on the consumer-facing side that nobody's complaining about. I mean, my mom is not complaining that Gmail gives her unlimited storage or anything like this, that Facebook is a free platform for her, that she doesn't have to sign up for Prime if she doesn't want to. The other aspect of your analysis, I think that is so tricky, is data. And we reference Standard Oil, right? I mean, some people have said data is the new oil. Data is the sort of fossil fuel that we've created, that we live on now. These companies, so many companies live on. What is the role of data in antitrust analysis right now?
Data is, as you mentioned, a critical aspect of today's product offerings. Data has a very important role. It can create incredible efficiencies for the consumers and improvements in products. The way we analyze data, we view it as data as a property. If you have collected certain information, we have forced divestiture of data in a merger, where the two transactions, you have two sets of data, just like any other, like two sets of, I don't know, let's assume that there's a product market for statin drugs, and there's only two of them, and if those two companies merged, we would likely force the sale of one of them. So we have to take a look at the quality of the data. The other important thing, and I'll refer you to my friend Hal Varian, who may be here, is, and others who are experts of this, data cannot just be lumped into one lump. We have to look at user data and usage data. User data is non-rivalrous, meaning that you and I can, you can give Brian Sullivan at nbcu.com or whatever your email is and your phone number and your name.
Close to my actual email address.
I just took a wild guess, but you can give that to as many people as you want without diminishing its value. Whereas if you had $10, you could only give $1 to 10 people, and then you're out. You could borrow money, like the government sometimes does, to continue to buy that, but that's a whole different story. That's a different panel.
That's a totally different panel, different conference.
But what's important is that you can give that information to as many people as you want, and the technological, the technologies that are available and the cost of collecting that data has gone down. So whether it's your local cleaners to Google or Microsoft can still collect that data. Usage data is a little different. Now, Brian's usage and purchasing history over the past year is something that some companies may be collecting. However, your usage from at the end of this year to the next year is going to be completely different, and that's something not anybody else can collect. So you have to put a different value on usage data as opposed to just a plain old user data, which could be information about you.
Are you, if I'm reading between the lines, are you suggesting perhaps that predictive usage of data is more insidious in some way than simple, Brian went to the store? Not
necessarily insidious. I think that it is much more, valuable. It's much more unique. It's not one where, if you are giving your information and he has been collecting information on you the last 5 years, and then you move on, and you can't give that same information to the next person, unless I guess the government forces you to do that. But if he has spent money and invested and collected that information and is using it for whatever reason, and assuming they have continued to follow their privacy rules and the commitment to the consumer that some companies may not have lived up to, but that information is unique, it's valuable, it could be incredibly valuable, might have zero value, but it could be very valuable. But that's something that he can't replicate. Your email, your cell phone number, your name, your date of birth, and all that could be replicated, but that usage of the previous 5 years may not be. So we have to put we look at that in a different manner than we would just look at user data.
Do you feel that the consumer needs to or deserves to understand more about the data that's collected on them and how it is used?
Absolutely. I think there is, and I think, over time there might be revealed preferences by the consumer about how they might treat that, and they might give a different value system. You may have been a lot more willing to share your information 5, 10 years ago with a website that collects it. You might be, now that the public is knowing more about what is being done, and I don't know how much of the public knows how much of the data is collected and their usage data, but you might be less and less likely to do that over time. And I think we're seeing some of that in some of the data on consumer preferences we're seeing.
I just wonder, can we even absorb it as consumers?
I think
could we even understand it? I don't know. There's so many smart people in this room, and I read some of these disclosures, and I have a law degree, and I can't understand them. I don't know.
How many times have you signed mortgage documents, and you have a stack about 3 inches, and you have to sign almost every other page, and even if you read it, you would actually understand what the heck that said.
For the implications of what it means.
For the implications of what it means. But, you do that, and probably with every one of those signatures, there was a lawsuit that led to it. But that is an important element that you raise. Does the consumer, do they really understand what they're giving up, what is being done with their information? And we don't have a comprehensive regime for that type of privacy, type of protection, that disclosure. What we do with the Federal Trade Commission, when they enforce the consumer protection laws, is that if you have promised to use it a certain way and then you don't do it in that way and it's deceptive or unfair practice, then there's an enforcement authority. Otherwise, we don't have a generalized system to do that in this country yet.
What would be a bad use of data?
It's a good question. I think that gets into specifics of
if
the law.
If I search for Aspen restaurants, and then I'm on my email, and look, there's a pop-up ad for an Aspen restaurant. You could argue that's a very efficient and good use of my data.
Totally.
They're solving a problem for me.
Yes.
Right? If I like Bloodline on Netflix, I like it when they refer other shows. People who like Bloodline liked Ozark. Oh, what's Ozark? Oh, I like it a lot. These are efficient, I think, and relatively good for my time. They've solved problems. What's a problem creating use of data?
And as I mentioned at the beginning, those would be the types of, I think, examples of pro-competitive or consumer welfare enhancing types of uses. What would be negative? I don't know. Maybe if it's you have, provided information, and again, I'm getting way outside of antitrust, so it's not specific to an antitrust violation, but if there's been a commitment that you provide this information, you go on a website, let's say a health website, and we won't use this, we won't sell it to third parties, we won't be using it other than to provide you information, and you want to learn about, brain cancer. Next thing you know, that information is provided to people that is a violation of that commitment to you, whether it's insurers, your employer, your family members, whomever that might be, that violates the trust you put into that. And I think that would probably, most people would agree, that would be a bad use of the data.
Yeah. There's other stuff. I need to look at my notes now because we talked about so many other things, and I kind of was just going on a on a thing here. Look at this. I mean, it's really, this is such the key topic here. I think, I was just in Asia a couple days ago, and you go to Europe now, and it's like any web page, it's like accept the cookies, and Europe has gotten much more aggressive. And I think you said it best when you said that, Europe doesn't really ask, they decree. Right, they don't do investigations, they kind of just bring it down. You just recently, I think, either created or signed a part of or sort of led a group of 70 countries in sort of just a cooperative agreement. Can you dig into maybe more of what that is and how it may work practically, globally?
Sure. So I think what you're referring to is the first of its kind in antitrust. Multilateral agreement on antitrust enforcement and investigations that we had. I had announced this idea to do this, and 16 years ago I was at the Antitrust Division as the deputy for international and appellate, and so I had some time to think about this before coming to this job. But I thought it was time, partly because you'll hear from folks, true or not, that foreign antitrust agencies may be using the antitrust powers in a discriminatory way, in a xenophobic way, to harm a subject of another country. And it should raise concern for all enforcers. And before I was even confirmed, I reached out, and Commissioner Vestager from the European Commission was in town, and I said, look, we should all, are we all in agreement on this? She said, yes. We don't take discriminatory action. And I said, well, we should lead the way and try to have a multilateral agreement amongst all the agencies. There's about 138, at least as of last Friday, antitrust enforcement agencies around the world. I joke.
How many?
138. 138. 138. And,
How many countries are there?
Yeah, exactly. So we have a lot. And that's a good thing, I think, for consumers, but assuming antitrust is applied appropriately based on modern thinkings and economics. So I joke that, it is one of our greatest exports out of the United States has been antitrust law, but it could also be misused. So we have a number of efforts where we are working towards convergence, at least common understanding on the principles of antitrust law that we hope are adopted by everybody, and by and large, it's been working well. That doesn't mean there might not be problems down the road. So what I thought would be good would be a multilateral agreement on basic understanding. These are a number of principles of due process. This is transparency, right to counsel, conflicts of interest rules, non-discrimination, most favored nations. And it's about a dozen or so principles that I announced at a Council of Foreign Relations speech last June. Nobody thought, in fact, many people tweeted, a Trump administration proposal for a multilateral agreement. How likely is that? How would foreign countries adopt this? And I was glad to say that in Cartagena in May of this year, we had something about 60 original signatories to the agreement. We have a little over 70 now. And I think it's not only great for just creating due process and investigations, but it also elevates confidence in enforcement actions by our foreign trading partners. And it's something we can build upon as we move forward. Antitrust is not something where countries are going to do away with. Yeah. So they're only going to build on it, and there's going to be more and more countries involved. So I think it's important for everybody who might do business globally.
On that, so I have purposely sort of not gone into the political side. There's too much of that. I think we all agree. So, and I wanted this to be focused on what you do, and it's just everything now becomes political. You can talk about a baseball game, and it's politicized. It's a giant hotel in Greenland.
I appreciate you not doing that.
Should we buy Greenland? No. Anyway, but yet you've worked in a number of administrations.
Be two new senators.
So generally, how much does your task, does the DOJ's antitrust division, or just the DOJ, how much does it evolve from administration to administration?
What's great about antitrust is I think you have a general understanding about how the laws are applied, and not much. Now, you have differences in the approach. One sharp, I think, difference might be the approach to remedies of a merger. I've taken the view, and I was criticized by some and praised by some, as is done. It's not really a political issue because a lot of my colleagues who are Democrats agree with me on this. It is that when you have a merger, antitrust, we're a law enforcement agency. We're not a regulatory agency. Congress didn't give us the power. In Section 7, does it substantially lessen competition? If so, block it or remedy it. And I'm of the view that for the marketplace, it's best if you have a structural remedy, meaning that if there's a divestiture of a problematic asset, but the rest of the transaction is very pro-competitive and efficiency enhancing, that's a good thing. And let it go and then sell it, as opposed to behavioral decrees that the Justice Department imposes on the companies. Let me give you an example where people are lined up a mile long outside of our door in the AT&T Time Warner transaction. This is horrible. This is not a good deal. You should block it. You should not block it. You should put a decree that says 20% of what DirecTV carries must be minority-owned content. A laudable goal, not an antitrust objective. That could be, within the FCC or otherwise. This is horrible. This needs to be independent content. Again, laudable goal, not an antitrust problem. It could be, if there's a lot of competition, you might have different markets for that, but it's not something where I come in and impose that, you must give somebody of particular ethnicity a 2-hour primetime news show as a condition of approving this merger. That's not purely hypothetical, by the way. And it's
not?
It is something.
You read about that? I'm sorry.
And
did that actually happen?
I'll let you do your research.
Part of a massive deal was some talent wanting a 2-hour show?
So this happens quite a bit. And people come in with, divestiture buyers or acquisitions, and they come in. It wasn't Brian. And they come in and they say, hey, we have, a minority-owned private equity firm that's part of this. Would you approve this deal as opposed to this competing deal? And I said, look, it's just not antitrust. Go to the FCC. They might factor that in under the broader public interest test. I don't know, but it's really not a power Congress has given us, nor should we do that. Or another real matter where we imposed as a condition of approving a merger, one competitor installing refrigeration and air conditioning in the chicken coop of another of its competitor. That's just not the role we should be engaging in. Just because we have the power to impose those conditions on merging parties and impose that kind of a tax is not something we should be doing. So where there's a structural remedy available, that's what I have favored. Some people have criticized it, but such is life.
You have been busy, too, because you taught T-Mobile Sprint, which I'll probably get a question in toward the end here. I know we're running out of time. Sinclair Tribune failed.
I thought we approved that. Is that still pending?
What is that?
T-Mobile Sprint?
Well, some states apparently have an issue. So I'll just ask it right now. Where does that stand now that states have sort of flexed their federalist muscles?
So it's interesting, federalist. New York and California state AGs led a number of states while we were still under the review. And that's an investigation that we were doing jointly with the states. Let's say we have a confidentiality agreement and a common interest agreement, and it's been reported that in violation of that, states jumped ahead and brought a lawsuit. Makes you wonder why they did that. And I know my friend Phil Weiser was recused from that, although Colorado joined that transaction, that litigation. I think the solution we have, and we filed with the court and is pending the Tunney Act review, is a great solution, ultimately pro-consumer and pro-efficiency. But the states did that. Whether or not that lawsuit remains, they now have to litigate not the underlying transaction, but the fix that we have. So the transaction as fixed by the FCC and the Justice Department. And so we'll see what happens in Southern District in New York. Is it an efficient use? I don't know. Was it motivated by, state AGs versus the Trump administration? I'll leave it to your viewers.
So your friend Phil,
Yeah.
Monday night,
Yeah.
who was in the courtyard for Phil on Monday? Phil was a little tough on the DOJ. He basically, your friend Phil was not so complimentary of the Department of Justice.
I liked my friend Phil better when he was a law dean and when he was an antitrust division official. He now has, I think, a public role as an elected political official, and he has to say a number of those things, which I don't doubt that he believes in. I don't agree with it, and I think it's really dangerous when we start questioning, not that we shouldn't do proper oversight, which is great about our system of checks and balances of the Justice Department, and we've seen, certain questionable practices, particularly the FBI, but I think if you start questioning the motives just because for political gain of institutions like the Justice Department, it starts being real problematic, because if there's a public perception that the decisions that we make are not based on the laws and the facts, but it's based on some political motive, it's like questioning, judges and the Supreme Court's motives. And once we do that, I think it becomes problematic for the country as a whole.
I think you've made me you should have made a lot of people in this room very happy just now. Because Phil said basically used those exact words, that we cannot politicize these institutions, that we risk degrading their value. And I find it comforting that at least maybe two opposing sides in a variety of ways, federal, state, whatever political view you have, actually believe the same thing. So I think we should all take that as a positive. But it does bring up a larger point, which is, do you feel sometimes that, and maybe it's T-Mobile Sprint, as you semi-alluded to, that states will do stuff purely for a political reason in antitrust, which is not necessarily an antitrust issue?
I don't know. And I think, look, they brought the case before there was the remedy that we imposed. Faced with that same exact matter as it was unremedied, I probably would bring that same case. And I've said that. So, the underlying, the process that led to it is what makes me question the motive. The underlying fact I don't have a problem with. We'll see what happens with that trial going forward. But, I think let me give you an example. AT&T Time Warner, highly visible transaction. It was a matter where we worked with the states. It started the investigation prior to this administration, certainly prior to my arrival. And that had continued. And some states, AGs, were involved. And, prior to filing, several states had expressed an interest in joining. But, for whatever reason, they didn't. But one particular one, just, I think about, particularly when you ask that question, said that as a condition of them joining the lawsuit in AT&T, they wanted a specific commitment from the Justice Department that should there be a settlement and divested assets, Rupert Murdoch cannot purchase it. Now, if anybody cares about the First Amendment, that should shake you to the core. That demand that the government would impose, some may applaud the goal of that, but imagine if it was one where it says, Brian Roberts can't buy, some assets that were divested as a condition of joining. And I just said, I think I'd be violating the First Amendment by doing that, so go to hell. And they did not join the merger enforcement. I think to the extent people are thinking in those terms, that's not good.
Now, is this Slido thing supposed to work? I don't have no idea. There are questions.
That's a phenomenal technology, by the way.
Keep talking. We
Without
got 5
endorsing
minutes.
it, I
We've got
think
a
it's been great.
spectacular panel after this, right, Laura? I mean, it's going to be not as good as this one. Not near. Oh, it turned screen. Oh, there we go. What is the future of entertainment? Oh, here we go. There are questions. Okay, very quickly. Softball. Should Section 230 be repealed? That's not on the thing, by the way. That's mine. And by the way, 55 people who cornered me in the elevator the last 36 hours wanted me to ask you that.
Wow.
Hi, you're in a bathing suit. Should Section 230 be repealed?
Like Section 230 is, as many people may not know, is a provision of the law that has nothing to do with antitrust. It might have had some competition effects, but it is one that was part of a different set of laws that the Supreme Court overruled under First Amendment grounds, but then held the immunity provisions. I don't think back when that law was passed, the type of online information services that we see today was anticipated by Congress. But we should take a look at almost, I think, every law, but particularly this law to see, does it make sense? I'm not a huge fan of, private lawsuits that are just purely rent-seeking and nuisance. But to the extent that companies internalize externalities of their offerings and makes them improve and be more responsible, that can be a positive thing. So I think a review of Section 230 by those people who care about it is perfectly appropriate.
We have one. I'm going to only do non-anonymous questions. We're all friends here.
Sure.
We don't need to be anonymous. What is the DOJ's next step in its recently announced broad review of online platforms? From Tony. Thank you, Tony.
I think in a normal investigation, we seek documents and information from parties who might be affected or feel like they have information about it. Is a typical investigation. We get that. We might be issuing, compulsory process on some third parties who may or may not need it for whatever reason to provide more information to us so we can properly evaluate. And then, of course, working with the parties. And I have to say, the parties immediately had reached out to work with us in a cooperative manner to provide information that we need as part of the investigation. So I was heartened by that, by the companies that were subject to the investigation.
Drew from broadbandbreakfast.com. How did the possibility of spinning off T-Mobile Sprint assets to Dish become an option for consideration? That's a really good question.
Drew is known to have good questions.
I wish I had come up with that question. Good job, Drew.
Drew is somebody who's not unfamiliar to this world. He very capably handled the Microsoft investigation from soup to nuts 20 years ago. Here's how it came about. When we looked for a divestiture that would solve, solve the competitive harm that we identified from the underlying merger, but still harnessed the very pro-competitive elements of that transaction, we looked to see who could step in and build another network. There were only two other companies, I think, that were in the space that had any spectrum. I think Comcast had about 10 megahertz of spectrum. Dish has about 95, which has not been used. So it's been sitting idle, not to the benefit of consumers. Sprint also had a good chunk of spectrum at the 2.5 megahertz that was not being used. So I think ultimately the solution that came about, and who knows, it may not have happened that way, but how it came about and the way it has come about is one where I think it'll be not only very output enhancing, because you've just taken almost 200 megahertz of spectrum that is not being used today, and most likely would have gone to the two incumbents that are the big players in this space, and are now being used by a third and a fourth to really create competition and new offerings in 5G. That capacity will force greater not only quality, but probably price effects here. And so I was pleased that this is the way, the solution that ultimately ensued in that matter. And I'm hopeful that the transaction will close, hopefully sooner than later, so that people can start building and the competitive forces can begin.
I know we got to wrap it, and everybody's been very generous and over our time. I want to leave it with some practical advice. Help out the audience. You referenced the line of people outside of your door for AT&T Time Warner. What is the biggest sort of mistake companies make in dealing with you in your office? And what's a piece of advice you would give to people in this room who could then relay back to their attorneys on how best to deal with your office? What could they do better?
Well, first, I think, as early as possible, get the data, get the information that you think would be relevant to our investigation. Don't try to hide the 8-ball. Don't try to delay and, not produce the second requests. We have no qualms about going to court and enforcing our CIDs to third parties in our investigations and otherwise. We have done that. It hasn't been done in a long time. Twice, literally came down to the last 30 minutes where the parties finally said, okay, we're going to turn it over. And we didn't go to court, but we're fully prepared to enforce our process to preserve the integrity of the investigation. Second, I'll refer you to the private litigation between Tribune and Sinclair. A lot of information, inside information, was specifically mentioned in that complaint. I think that complaint shows what not to do if you're a merging party in the front office of the Justice Department. So that's it. But look, we look to do what is right in a transaction. There was a merger about a year or so ago in the software industry where we probably, based on the documents, could have brought a lawsuit and probably could have won. The parties didn't do a great job of defending it, but when we looked at it, we saw that the barriers to entry were very low. The actual margins were not huge. The CEO came in and said, oh, we're just buying this competitor because it's a lot cheaper to buy them than compete with them, which is usually not a good thing to say for antitrust enforcement. But ultimately,
is he still a CEO?
I don't know which of the CEOs. One of them is probably living comfortably on the beaches in Santa Barbara. The other one is still the CEO. But it was one
They're
where
walking around Aspen with a Patagonia vest and a Bernese Mountain Dog.
It could very well be. But I think
I just described 600 people.
All the folks there. But I think the lesson of that is that what we will ultimately do is we probably looked with our economists and our investigators to do what ultimately was right, and we probably did a better job defending that merger for the market. So our goal isn't to just go out and sue and win. It is to get to the right result. So I think that should give some people a lot of comfort.
My goal was to have a broad antitrust discussion with you. I did not anticipate this news last night and this morning, so I want to personally thank you. And I know thanks. You were very gracious with your time. It was a lot more broad-based than maybe we had planned, but I don't, I like my job. So thank you very much for that wonderful use of your time. I know the audience appreciates as well. And thank you to the other panel for letting us eat into your time.
Thank you. Thank you. Thanks so much. Appreciate it.
That was a very, I think we all learned a lot. Thank you very much. And we'll see you around the building. Thank you.
Good job.